Hello, good evening and welcome to the Hot Seat. During a time when the people's conscience has been aroused, especially in terms of good governance, we thought we'd have on our program a legal expert. In that context, this evening we are joined by Mr. Krishmal Warnasurya, legal expert, attorney at law, amongst several other things. Good evening, Krishmal, and thank you for being in the hot seat.
Good evening, Faraz. I hope I'll enjoy being in the hot seat with you.
I'm sure you will. Krishmal, the people of this country voted in change, and this was achieved under the promise, I was going to say under the guise, but under the promise of good governance. There have been several improvements. One of those is, of course, the freedom of the media to say and act responsibly, something that hadn't been done before, or it was, but it sort of eroded. Now, in that context, we have a situation about the central bank. Various allegations being made that there was a questionable transaction in February, March 2015. The Prime Minister appointed a committee to look into it. COPE went into it, and several hours ahead of the release of that report, the President dissolved Parliament. The Prime Minister promised that another investigation would happen under the new Parliament, and we are told that that is now started. So is it fit and is it proper that the governor of the central bank, whose term is coming to an end, is it fit and proper that he be given a new contract whilst an investigation into these matters is being carried out by COPE?
It doesn't appear to be right at face value. Before we get to the law, I mean, obviously there is some law on this, on his appointment and that sort of thing. But as citizens, as you speak of the good governance that we try to usher in, like you say, the positive angle of it is that out of the several positives we thought we'll get, at least one positive we have is that we can discuss these things now. So, at face value for us, I also feel that since there is this question hanging over the individual concerned as to his conduct, particularly as to his conduct as governor, which is a very important position. In my opinion, that position also ought to have, because it's executive appointment, that also should have gone into the list of appointments that are vetted by the Constitutional Council. But that we were not able to when we drafted the 19th Amendment. I don't know, it missed all of us, or it was never there. But going to what it is now, I think it's proper that he awaits and not be appointed until the investigation is concluded, which I believe has now been picked up by Parliament, because a couple of days ago I heard very senior members of Parliament, both at a press conference and during the debate on the no confidence motion, calling upon the President and the Prime Minister not to appoint the particular holder of the office now until those investigations are done. I mean, they actually didn't say until, they said not to appoint him. But in my opinion, from a point of law, there is an inquiry. I mean, even in a public service, you know, at a very middle level or executive level, when there is a pending inquiry against a person, you immediately either discipline him or take him away or interdict him pending inquiry based on the grievousness of the allegation, so that he cannot take part or impede in an inquiry that's going on. But if you appoint a person whilst an inquiry is going on into his conduct, that person may be able to influence that investigation. So from that legal perspective, I believe it's good if he is not appointed until he is cleared.
In the same context, we had recently the appointment of 2 additional secretaries to a couple of ministries, and there was a hue and cry about that. And they then say, and these 2 individuals were, I think they had already been produced before in court, and so there was this couple of matters that were outstanding. and so people, they took note, and so that was it was reversed, that appointment. So in that context, how does the appointment or the reappointment or the offering of a new contract to the same person who is still essentially under investigation, how does that sit with the wishes of the people?
Yeah.
What can the people do?
Good question. Good question. Going back to your first question, how does it sit with the wishes of the people? I don't think it will be the people's wish. That and particularly this particular appointment, I don't think when you give a contract to 1 or 2 years, it's about 5 years. 5 years.
It's a 5-year
So
term.
I do not think that the people of this country would wish for an appointment to be made for 5 years, particularly when someone is under investigation. Say for instance, over the next 6 months, he's proven guilty of whatever that's been alleged. Then what are you going to have? Are you going to have a guilty man in office for the next 4.5 years then?
Yeah.
And once you're appointed, they're appointed in this position. There's a whole process of getting him out of it. It's not as easy as hire and fire.
Yeah.
So I think in that sense the people would not want it. But going to as to what can the people do for us, we need to understand the three pillars of government, how they work. Now we have the legislative arm of government, the parliament primarily. COPE being a member of that institution is a investigative or inquiry arm in the legislative power of the people. You see, sovereign power of Sri Lanka is held by the people, absolutely. And that is what the constitution says. You can't get beyond that. So sovereignty is in the people and that's inalienable. But for the time being, we give this sovereignty in public trust, for our benefit to three institutions. The one is parliament. And then in parliament we have COPE now inquiring into the matter. Then we have our executive power, which is also part of our sovereignty. Our legislative power is in parliament. Our executive power we give to a president to work on our behalf, and he works in terms of Article 4B. Also in Article 43, he works with the cabinet of ministers. Executive power with the president as a prime minister and a cabinet who works with him, exercising our executive power. Now it's our executive power that makes his appointment in terms of the Montreal law. The governor is appointed by the executive, the president. Now, the judicial power of the people, Article 4C, is exercised by the judicial institution. So these three pillars of government are neither superior nor inferior to one another. They work, we call it a separation of law or a separation of powers. They are separated but they are equal. They work together for the people. It's called separation principle. Now, if the executive that we have appointed or our executive power is going to appoint someone that our legislative power is now checking on.
Right.
You follow?
Yes.
Our legislative power which is in parliament through COPE is checking on this.
Yes.
And our executive power is now going to appoint that man.
Right.
And what do the people who are sovereign power? It's our sovereign power.
Yes.
So we need to go to our judicial power and say, look, these two
To stop
and say, do something.
the executive.
To stop the executive. Because the executive is trying to do something that our legislative power is now checking on.
On that note, we'll take a short break and come right back. Stay tuned to the Hot Seat. Welcome back to the Hot Seat, where we have in the Hot Seat Mr. Krishmal Warnasurya, a legal expert. Krishmal, now we've understood this bit where the people would have to exercise that sovereign right, would have to petition the judiciary to stop the executive from making an appointment whilst that person or organization is being looked into. How successful is that a given in law?
Yeah, well, if you earlier, of course, there would have been a question because, as you know, our constitution allows a certain immunity to the executive president. Right? So, in the earlier, of course, even earlier, if you remember the Lanka Marine Services cases and the Insurance Corporation case and all that, even whilst the president enjoyed that immunity from suit under Article 35, we still went to court and we challenged acts of the president, and the Supreme Court accepted that was a valid and that was a given. But now, after we amended Article 35 in our 19th amendment, the president is, for his official conduct, the president is answerable to court, in particularly in an application under Article 126. Now, the amended Article 35, the amended Article 35 of our Constitution, which gives the immunity to the President, earlier immunity, we now amended, when we amended, brought in the 19th Amendment, we particularly put in provision here saying that whilst the President holds office, he enjoys immunity, but provided that nothing shall restrict a person, any person, from making an application under Article 126. That's a fundamental jurisdiction.
Right.
We feel our fundamental rights have been violated, any citizen, nothing shall stop that citizen from making an application for the official duties of the President via the Attorney General. So we can sue the President in the Supreme Court for a wife. We feel that by appointing this person, in my opinion, if a person is under investigation for acts of misconduct whilst in office by a legislative arm, and then our executive arm is going to make that same person go on for another 5 years, in my opinion, our fundamental rights are being infringed.
Right.
If any person feels like me that their fundamental rights are being infringed, they can make an application under Article 126 against the official acts of the President via the Attorney General.
Right. See.
So we have a right to do that.
Right.
We have a particular right to do that now.
So there is an option available
There is an option
to us. But Krishma, there are instances which, under the Monetary Act, the central bank doesn't have to disclose information to anyone, even to a court of law.
Right.
How does that sit then with our predicament?
Yes, those preclusive clauses, we call it preclusive clauses, preclusion, that that so and so shall not, or the acts of so and so shall not be questioned. Now, it is a fundamental in law that such preclusive clauses anyway don't apply to the Supreme Court or the Court of Appeal that exercise extraordinary jurisdiction.
Right.
Now, when you usually say that it shall not be called into question in any court, or it shall not be called into question in any civil suit or action, officials of public officials, acts or whatever, that action or suit refers to a civil or a criminal litigation in an ordinary court, but they do not refer to constitutional remedies like the Court of Appeal or the Supreme Court, which are called extraordinary jurisdiction, because those are constitutionally given, ex debito justitia, by virtue of the Constitution, by virtue of all sovereign powers, we are entitled. So that, number one, it doesn't stop persons from going to the Supreme Court. Number two, now once again I go back to the 19th Amendment, which some of us got involved in drafting. Once again we put a special provision now in the 19th Amendment that anyone is entitled to freedom of information.
Right.
Not the Freedom of Information Act that people were shouting about recently, but it is now a constitutional right in terms of the amended Article 14.
Right.
For any person. So, when there is a constitutional right that conflicts with a act of Parliament, the Constitution overrides. You follow? Because the Constitution is supreme law.
Right.
Or the Grundnorm, as Kelson says.
Right.
It's a Grundnorm. It's a main law. All other laws are made upon the powers of the Constitution. So when the Constitution says, I have a right to freedom of information, an ordinary law like the monetary law that says that no, you can't, that cannot override because the Constitution overrides. And in my opinion, the constitutional right given to a person to ask that information, which we brought in specifically by way of the 19th Amendment, overrides, and any person should demand for that information, and if they are not given, they should challenge it in the Supreme Court as to why my constitutional right to information was violated by any person not giving that information.
Now, that's all well and good, but if I want some information as to the details of, for example, the issues of the bond and who bid and what the rates were and how, who was awarded it, finally it's our money that is being awarded, or it places a risk or a liability upon the people's money. And if when they refuse, as they have now, and as confirmed by the chairman of CORP, there is a cost. And I'm told that it will cost upwards of ₹500,000 rupees to go to the Supreme Court. And all I want to do is satiate my inquisitiveness to ensure that I want to know, as a member of the public, whether the governor of the central bank and his officials are acting equitably and not placing us in even greater risk. But for that inquisitiveness and to resolve that in my mind, I'm going to have to find $5,000 or $500,000 rupees upwards to do that. That doesn't sound fair.
No. But you know the curiosity killed the cat, so...
Yes, yes, that's true.
Yeah, but so no cat should die in this whole process.
No.
But,
no.
but $500,000, I don't know where you got this figure from.
Yeah.
If someone said, I probably you would have information from somewhere.
Yeah.
Someone's trying to tell me that everyone who goes to the Supreme Court has $500,000 rupees to go to the Supreme Court for. I tend to disagree.
Okay.
People, there are specific arms of the judiciary itself that give legal aid to people who can't even afford to go to the Supreme Court.
Right.
Recently we opened a special unit at the University of Colombo, which I was also part of in the panel, to offer such advice to people.
So form of legal aid.
From a legal aid perspective, so no one needs to have $500,000 rupees to go to the Supreme Court.
Right.
Let's get that out.
Okay.
No one needs to have $500,000 rupees to go to the Supreme Court.
Okay.
Let's get that out of the way.
Right.
But of course there will be some costs involved, but then on this sort of public interest litigation, you will find that several lawyers have come forward and this sort of thing. Lawyers also, remember that we also swear an oath of allegiance on this constitution to promote and uphold this constitution and protect the rights of the people. So our primary duty is to court and to this constitution. And if, like you say, some person were interested in finding out as to what has happened to the people's money, there will be several lawyers out there who might take something like this on purely pro bono publico or for the good of the public. And that won't cost any $500,000.
But the other matter that is of sort of ironic value is that we have the governor of the central bank who's serving the balance of the former governor's term, but he's a foreigner, and he can take off at any time. So if the investigation finds out that there had been some form of missing funds or there was a substantial loss and we want to recover all this, he's not Sri Lankan, he can go away.
Well, once again a misnomer.
Right.
I first, to get on that first question of him being a non-Sri Lankan, I also realized this. At one time I think there was a discussion as to whether he even took the oath of office that public servants are supposed to take on the constitution of solidarity to the
but
state.
How could he?
Yeah, exactly. So that there is that question.
Yeah.
But I do not know the facts about his residency of his citizenship, so I don't want to comment on that.
Yes.
But as to whether foreigners, even foreigners working for the state, foreigner or whether he came from Mars or even the moon, if they have been employed by the government, they will not be allowed to go scot-free like that.
Right.
Our courts will assume jurisdiction over any person who has been being paid with public funds. And if person has been found at fault, he will be answerable to our courts, foreigner or not. So you don't have to be a Sri Lankan to punish him. Follow? But of course, he might, he or she who is not a citizen, may attempt to raise immunities, but diplomatic immunities and all that will not apply to persons who have been contracted by the state to work for them and paid state funds, where those immunities go out, because you have, by contracting yourself in, you have waived your right to any such immunity you may have as a citizen of some other country, where you have contracted to serve upon a contract. And if you have breached that contract, and if you have, particularly if you have committed a fraud under a criminal law, any such privilege as some other country's citizen will not apply. They will be found default.
And subject fully to Sri Lankan law.
Subject fully to Sri Lankan law.
That brings me in nicely with some other questions. Now we have Parliament voting for to provide concessionary permits for the importation of vehicles, for example. Just one example. Okay, so some of the people that these concessionary permits apply to are parliamentarians. Others, there are doctors, there are, and I know that you've represented some of those. But, why should the people pay? Okay, we understand a bit about providing these doctors, like, for example, because you're familiar with the case, with transport and so on. We have no problem with that. But why is it personal? Why cannot it be, why can't we have a central unit that provides transport services from the president downwards to doctors, to medical officers, or whoever? But why? And so that's a state thing. Why should we enrich these officials? Now, we don't have so much of a problem with, say, doctors, but we do have a problem with other officials. Why should they're there to serve the people? So why should it be personalized and where it benefits them? They take a permit and they sell it on. Is that fair?
No, it's not. It's not, and actually I think there is a preclusion on selling that permit. It's but they find ways of loopholes of doing. In fact, some of our colleagues have also approached me and asked me whether I can draw up a contract where, you know, well, I have this permit, I'll sell it to so and so, but the vehicle will remain under my name until these years go by. So when you get such a duty-free waiver or exemption or inland revenue exemption, you get a time period upon which that you can't vest this in someone else. Yeah. So they actually go operate beyond these laws. But going back to the principle, because I also completely agree with you, and I don't see why 1.18 billion should have been given on tax-free vehicles to these parliamentarians, because we ourselves saw in the run-up to that election for us, where we also got down on the streets and asked these citizens to exercise their right and change the regime. Fleets of vehicles being displayed on TV, on your channel, and on all other news stations, showing that these are brand new BMW top vehicles, Mercedes. I don't want to say brand names, but you know, top vehicles that were shown, which could very well be used. And I do not agree with these ministers at all who come up and actually try to justify it at press conference and say, well, we can't go to the villages in these vehicles. It is absolute rot, in my opinion, and this is not what the people voted for. And I believe now that some decision has been taken to hold on to it, which is very good, because as people,
but it's only temporarily.
Yeah, but can I get to the principal point of what you were trying to raise earlier?
Yes.
Is that there are, you see, the suggestion that you made was actually brilliant. I think they should have you in the advisory panel to the government of having a pool where the state procures the vehicles and gives it upon a need assessment basis.
Correct.
Now that would be an excellent way to do this, rather than give individuals permits.
Correct.
You know, that would be excellent. Because you see, there are people now, there are lawyer-client privileges with the doctors that I appeared for. So I don't want to comment too much on the case, but we managed to get some relief in, and those doctors will get their cars soon. You see, people, not just doctors, there are persons who are employed by the state who deserve to be given some form of transportation allowance or some incentive where, because you see, mostly doctors work in very rural areas, and sometimes they may be called to go here, there in the night, in the morning. So there is some incentive in affording them some transport. I don't mean luxury vehicle. I don't even mean a permit. I'm totally with you. If we can find a state system where there is a pool, or say under the transport ministry, say there is a pool of and categorized vehicles. Say these grades get these vehicles, or these grades get these vehicles. Now that would be an excellent way of doing it, rather than giving them permits. Yeah, but other than that, if you are even giving permits, I do not see the need to give this 1.18 billion luxury vehicles to. And what is the justification? You can't go to the rural area that particular minister was talking about, going to his electorate. No. In that electorate, you can't climb up those hills and mountains in a Mercedes-Benz. Then you have to go on a four-wheel drive.
He said they need good four-wheel drive.
So, well, you can get four-wheel drive, not for 1.18 billion. Now, one particular allocation was 70 million. 70 million rupees. When for us, the average, they say that average Sri Lankan earns 46,000 rupees. I don't agree with that. But the data says that we earn 46,000 rupees. There are persons that I know that earn only 15,000, 12,000 rupees a month and try to survive a family with 2 children on that money. You know, trying to do 2-3 jobs every day. At 70 million on a week for the people, for these representatives who have come on the poor people's money.
Why can't the people bring an action of sort of criminal breach of trust? Because we trust them when we give them their vote, our vote, to represent us in Parliament. It is based on the promises that they undertake. And so those are promises. And when they eventually end up in Parliament and break those promises, in my mind, it's a breach of trust. Can't we can't we test that in court?
You could. Criminal breach of trust may be going a bit
Too far.
You need to prove an element. When it's a criminal case, you need to prove an element of mens rea. We call it mens rea, the mental element.
Right.
That there was intention to cause this criminal.
But I think in this
much
case,
more than that in a public interest.
Yes.
In the public interest. It will be ideal thing to test. I know some countries have tested it, where manifestos given by politicians prior to an election, particularly in some states in America. In fact, I did a research on this just before this last election, where we could hold these representatives to what they have promised us. Manifestos have been tested in courts of law. Manifestos given by various politicians, when they specifically make an assurance that we will do this or we will not do this, and if they go and breach that have been tested in some states in America and successfully in courts of law, where in a couple of cases, I believe in my research, I vaguely remember, in the 60s or 70s in the United Kingdom, there was 1 or 2 cases where once again a manifesto was tested in a court of law. So it's not something that is unheard of in law.
Right.
But I can't remember any Sri Lankan having tested anything yet. It doesn't come to my mind. Maybe they have. But as you know, all lawyers are not repositories of all knowledge.
Yeah.
We only look something up when we need to look it up, with all the books that we have in the library.
Yeah.
So someone may have tested, but it may be an ideal case for a person to go and test it in a court of law.
So, Krishmal, bottom line is, the people can have a say. What are the chances of success of some member of the public petitioning the judiciary to stop the President via the Attorney General to stop, at least temporarily, the appointment of anyone who is being investigated by Parliament and through court for, let's say, the position of the Governor of the Central Bank?
I think the chances of likelihood, I'm putting myself online here by giving a public opinion.
Yeah.
But the likelihood of the apex judicial body, which is once again I said, the judicial power of the people, hearing a petition like this, I think are very high for this reason for us. You started with a very nice saying, what can the people do? Can someone go to the judiciary? You see, it's ultimately, as I said, the people that hold sovereign power in this country.
Yeah.
So, look at it from the judicial point of view. If I, a sovereign citizen, and am coming and telling my judicial holder of my judicial power, look, the holder of my executive power is now trying to appoint someone that the holders of my legislative power are checking on, are investigating for misconduct.
Yeah.
And I have nowhere else to go. I can't personally go and stop them from appointing him. I can only come to you, the holder of my judicial power. Now, what judiciary can shut their ears and eyes from such a citizen? And it's been done before. It's been done before. And now we have a particular, and also remember, can I quickly say, in our 19th Amendment that we drafted, we have a new 33A coming up. Now see, the following article is inserted immediately after the old Article 33. The President shall be responsible to Parliament. So it's a new procedure coming up. The President shall be responsible to Parliament for the due exercise, performance and discharge of his powers, duties and functions under the Constitution and any written law.
Right.
So now we have brought a new provision in our 19th Amendment saying the President is responsible to Parliament for doing his duties under any written law.
Right.
One of those duties under any written law is under the monetary law appointing the central bank governor. Now, if the President is not doing that duty in terms of the law, because he is responsible to Parliament, and now Parliament by cope is checking up on the misconduct of the so-called appointee, then in my opinion, he is violating this provision of the Constitution.
Right.
And where does one go to check that? To the judiciary.
Krishmal Wanasuri, thank you very much for having been in the hot seat. We look forward to seeing you on our network soon again. Thank you very much.
Thanks, Farah. Thank you for having me. Always good to be here.
Thank you.